Yes.
Yes. The first thing we're going to do is discuss the process for the interview. And I'd like to have the deputy present.
Okay.
Okay, so let's all have a seat for a minute.
Okay.
See if we can come to some resolution that will meet everybody's needs.
Will
So-
you just inform me you didn't want to fill out the paperwork?
I have filled it out twice now, and I'm kind of sick of filling it out
Hang on
many
a second.
times.
Hang on a second. What paperwork are we talking about, Sherry?
The initial packet information,
Okay.
the parent questionnaire,
All right,
the
so
parenting plan.
if
the
that's the
child
question, the custody study order calls for and requires the filling out of certain information as the first step in a custody evaluation. If that is not filled out, the FCS evaluator has no obligation to proceed with some alternative. They have two choices. One is they have no obligation to proceed and can simply be a non-cooperation, or they can proceed and get that information by taking extra time to get it orally, in which case you get charged $50 an hour under the order for that additional time over and above what the cost of the study is. The discretion is with the evaluator as to whether to spend that additional time. But if they do, then they are obligated to let the clerk know that they have to bill you $50 an hour for the time it took to get that information. That has to do with the question of filling out the paperwork. This is nothing specific to your case, Mr. Evenson. This is the standard custody study order we've had now for probably 10 years or so in Jefferson County. It's all been run by the judges. We use it in hundreds of cases. The second point that I want to make is with regard to the request to record. So there is a case, a Supreme Court case, dealing with the recording of court proceedings before a family court commissioner. The Family Court Services Office is an arm or branch of the court, so that ruling, in my opinion, would apply to them because it's not an entirely independent office, it is an arm of the court, Family Court Services. So it would apply to them as well. What that court case said, and it came out of Commissioner Guerin's court in Dane County, is that the presiding court official or the responsible court official has the discretion to exclude or limit recordings during those proceedings. They have an obligation to make record of their proceedings in some fashion, and that case, the only method of doing it that was done is principally by the court taking its minute notes. That would be the functional equivalent of Ms. Nagel taking her notes, which you would be entitled to. Nothing would prevent you from taking notes. A video recording, in my view, would be disruptive and interfering and unnecessary with the proceedings in the actual interview. There would be an opportunity, and I'll talk about that in a minute, if you want to take I'll talk about what you can do if you want to do a recorded proceeding of some kind. But the actual custody investigation interview, I've never been asked this question before, but as I'm thinking about it, I would not require Ms. Nagel to have a video recording of a custody study interview. I don't see any problem with having an audio recording of the interview. If you have a tape recorder with you and you want to set it on the table and you're both recorded, you want to do that, I don't see any problem with that. I don't see how that would be in any way disruptive, or I don't see any interference from that, to have a audio recording of the interview. Assuming the interview goes forward and after a custody study report is prepared, you have the opportunity, just like any other litigant in any case, to take a deposition. By local rule, you can't take the deposition of the custody study worker during the process. You have to wait till the study report is done. Then you have access to the study report and the records that are in it, and you can review that, take notes, you can get copies of things, and after you have done that, then you are entitled, or you or your attorney, if you have one, to take her deposition. Depositions can be taken simply with a court reporter, or they can also be taken with audio-visual depositions. And I would say that with regard to video, that should be reserved to the process of depositions. That's why the law sets out those series of steps. You certainly would be able to do that, but I'm not going to have her required to have a video recording of the proceeding, and I'm not going to require her to spend time seeking information that can be provided and should be provided in the filling out of papers. If you choose to fill out the papers, that's fine. If she chooses to conduct an interview and send the clerk the information to bill you for the extra time, that's fine. That's her choice. What do you want to do?
First of all, I have a question for you. So you said the state is the one that says whether or not this is a branch of the county jurisdiction, correct? That these people here are employees of the county, correct? First of all, I'll ask that question.
What's the question?
That she is also an employee of the county, correct? Just the same as you and just the same as this gentleman right here, the deputy, correct?
Is she a county employee? The
Yes.
answer is yes.
Okay. So you're saying that this is a state law that would prohibit me from filming, correct?
I did not say there is a state law that prohibits you from filming. What I did say is that there is a reported court case that came up on an issue out of the Dane County Family Court System. Do you want me to answer?
Yes,
All
I
right.
just,
If
that
you
was,
ask me a question, Mr. Evenson, I'm only going to answer a question if you listen to my answer. If you do not listen to my answer, I will no longer respond to your questions and we will terminate the entire process today. The answer to your question is no, I didn't say there's a state law, for example, written in the statute book, but there is law that is court-made law by the Supreme Court or Court of Appeals when they publish a decision on a particular question. That's law. The Supreme Court dealt with the question of a party wanting to record proceedings before a family court commissioner. The family court commissioner's office, just like the Family Court Services Office, is an extension of, or arm of, or branch of the circuit court. The Family Court Commissioner and the FCS office only exist by statute as that relates to, as an extension of the court itself. Therefore, my legal opinion is that the rule that the Supreme Court set down to govern proceedings in front of the Family Court Commissioner, by extension, applies to Family Court Services because they have a similar status vis-a-vis the court. They're an arm of the court. Therefore, the one piece of law that I know of on the question says that the court can make the decision as to whether to allow either a recording of the proceedings by parties in the proceedings. And therefore, yes, I think that we have discretion, and I'm the Family Court Services Director, as to whether to allow video taping of custody study interviews. That's my answer. Did I answer your question?
not completely. First of all, Supreme Court has ruled that any public official, officers, judges, any employee employed by the public is allowed to videotape them at any time, correct?
I don't know that.
Yes, that is a federal, been approved by the federal court systems.
Okay. Well,
So, yeah, by extension, that makes you a public employee, her a public employee, and him as a public employee,
All right.
correct? So, by extension, your ruling doesn't oversee federal law, correct?
No, I don't agree with you because the
Because-
decision that I'm talking about governs court proceedings, and that's fine. If you wanted to raise this question beforehand, you could have done that. You're basically saying you don't agree with my decision, which is fine. You don't have to, but then we're not going. And the other question is, are you going to fill out the paperwork or aren't you?
The paperwork I filled out twice already. I've already sent them here to Jefferson County, and I want to know why it has not been received, supposedly not received.
To whom did you send it?
To the Family Court, Circuit Court, is what I filled out on the
You mean
address.
what you wrote on there is Family Court Circuit Court? Well, that would ordinarily make its way then to the clerk of court's office. When did you send it?
Family.
Would ordinarily make its way then to the clerk of court's office. When did you send it?
The last packet I sent as of last Friday.
And have you checked with the clerk to see whether that's in? Could you please have her do that?
Yes, we have. No, it's not.
Okay.
Mr.
It has
Peterson?
not been received. My question, I gather from your answer that you are not going to fill that out to facilitate today's interview. Is that correct?
No, I did not say that, did I?
Well,
You're putting
you
words in my mouth and trying to tell me that's what I'm
answer
saying.
me now.
Answer you now? At this time, I don't really wish to.
Okay.
But-
Our process here today is now ended because Mr.
This is not even a formal
cooperative.
hearing, sir, so how
I
can
know
you
it's
give
not a
anything?
hearing.
So then why don't we have a hearing about these things? If we
don't
have such
need
an
to have a
issue.
hearing about this. This isn't something that requires a hearing. This
Okay.
is an administrative matter within my responsibilities as the FCS director. I'm going to ask
So you
the
guys tromp
officer-
over my rights even more and more, correct?
Deputy, please remove Mr. Evenson from the premises.
Will do, Commissioner.
By the way, if for any future things, your name again is
My
Commissioner.
name is Michael Lonheimer, Family Court Commissioner. Please remove Mr. Evenson from the premises.
Public facilities, you cannot remove people from public facilities.
Can.
Oh, you can't exactly.
Just directly.
Well, that's good. And is this in a court of law right now?
This is the Jefferson County Courthouse, I believe you know
Yeah,
that.
but is this an official?
You just talked to him, you know he's an official of the court.
So this is a hearing that he's given ruling on, correct?
You've already been answered, asked.
You didn't
answered.
answer. You
I
didn't
did.
answer.
So did the Commissioner.
Okay.
Out the door.
So basically, you guys are violating my constitutional rights now? How much more trouble do you guys want to get in about this stuff? So when can I return?
Call the Commissioner and ask him.
I can't call the commissioner. I don't have any
You need to
direct
go.
access
You
to
need
a
to go.
commissioner.
You have
Sir,
direct
I
access. You have a telephone. Isn't that a telephone?
yeah, sir, I need to know
Is
what I
that a
can.
telephone?
Can you get that
Is that a
information?
telephone?
Sir, why are you screaming at me? Why do you
I'm not
need to raise your
screaming.
voice?
You need to leave.
Why do you need to raise your voice, sir?
Goodbye.
Sir, what is going on? Why will they not answer my questions? When can I return, sir? When can I return, sir?
I told you to use the telephone and ask.
When can I return,
Goodbye.
sir?
If
When
you
can I
don't leave,
return,
I'll
sir?
arrest you for trespassing. You've been
On
officially-
public land, you're going to for trespassing?
Yep.
That's a joke.
Goodbye.
No, sir, I think you need to get a new job. Thank you, sir.